Good afternoon, everybody. A very warm welcome to this webinar, second in our AXA Schemes and Delegated Authority series. This one being dedicated to management liability, or MLP as we tend to call it in AXA. Some people will know it more typically as D&O. We'll get to why that's not entirely accurate before too long. As I say, my name is Sam Houlden. I'm Senior Development Manager in AXA Schemes and Delegated Authorities. Started off life as an underwriter, 10, 12 years experience, and then moved into relationship management about a decade or so ago. So I've kind of seen these products from both sides of the desk, as it were. We've got quite an exciting agenda in store for you today. We're going to be discussing, as I say, management liability in the round. We will talk about the context of it. We'll talk about the increasing importance of management liability insurance in the modern business environment, and especially when you consider the wider economic climate at the moment. We will talk about the constituent parts of the typical management liability policy. We will highlight some of the features. We'll talk also about AXA's own specific MLP product. I mean, you know, it's not going to be a hard sell, but at the same time, it's important to put into context what each of those various sections does. There are a couple of sort of USPs or you know, very, very key points that we will cover off. We'll also discuss some kind of real world examples of how those covers which exist within the product actually behave and under what circumstances they would react. That portion of our presentation is going to be delivered by my colleague Laura Roberts, who is our senior MLP underwriter in AXA SDA and probably knows about as much as the product this side of our technical director who wrote it from the ground up. So we're very lucky to have her. We will then be moving into the next portion where we will be talking about radar. This is going to be presented by our good friend James Barnett from Radar, who's going to explain more about the unique role that they play and why that part of our own proposition is so pivotal. I will again just lean into Slido and ask any of those who've just joined us recently if they can log into that so they can put questions to us throughout the course of the webinar, which we will then hopefully get a time to cover off at the end. As I said, there is also a bit of an icebreaker poll on there at the moment, which I think is underway as we speak. It is indeed. Yes, I can see lots of votes coming through there. So as I say, yeah, that's how we will interact with you throughout the course of the call. Yeah, and thanks for joining us today. Thanks for finding the time in your no doubt extremely busy schedules. But let's kick off and delve into the world of management liability. So I am going to pass over to Laura.
Hi, everyone. So thank you for joining us today. So as Sam has discussed, we're going to talk about the management liability policy and we'll go through the sections and some of the key messages that we want to deliver today. So the AXA policy is very much a proactive policy rather than a reactive policy. It's there to assist the clients and the insureds to make sure that they're doing the right things for their business and from their point of view, following the right processes and to mitigate any chance of a claim coming in rather than just reacting once a claim is made against them. We very much want to support the insureds, and we use this by our unique partnership with Radar, who are a law firm and are very much there to provide support and advice to a client for all business related matters. Reduced excesses that we offer under the EPL section. Excesses are a big thing in the market at the moment. They can be quite wide depending on which policy you're getting and who from. The AXA policy has an offering where it's a £10,000 EPL excess to begin with, but it reduces to £1,000 when they use Radar, which is part and parcel of the policy. So it's very much a kind of key selling point to follow that advice, get the right processes, and you also benefit from a reduced excess for that. And to talk about the policy and how it's a market leading policy, there's wide cover, and I'll go into that in more detail now. So we'll just go to the next slide. So I'll talk about the management liability policy, and I'll go into more details about the 3 sections and why it's not just called a D&O policy. But some of the key features and benefits that I'll discuss today is one of the key things at the moment, which I think is really important and will affect a lot of clients in different sectors, is that the policy provides support against all UK regulators for investigations and prosecutions. It doesn't just respond to your common ones, which would be the HSE or the HMRC. In the UK at the moment, there's over 96 regulators for all different sectors, and the policy provides cover for all of them. We don't name them as well, so when new ones do come into force, for example, there will be a new regulator on the back of the Building Safety Act, the policy will respond to those. So any regulators that are created down the line, the policy would provide cover and support for the clients. It's wide cover as standard, so there's cover for employment claims, regulatory claims, pensions, suit claims, pollution. So not only does the policy cover anything for pollution claims, but there's also cover for pollution cleanup costs, which is not something that you see often in the market and is a real beneficial factor for certain sectors. Policy standard is any one claim limit rather than aggregate. So again, providing wider cover is standard. There are some sections within the policy that might have their own inner limits, but as a whole, it's any one claim. The policy provides full cover to rradar, which I won't go into too much detail at the moment because James will pick up that later on. I won't step on his toes, but it is all included within the policy. There's no additional costs for rradar. So I'll move into the different sections of the policy on the next slide. So the reason we call it a management liability policy is because there's 3 different sections of cover. We have the directors and officers section, which is your standard D&O, covering your directors, your officers, your trustees, anyone in that role. The next section of the policy is your employment practices liability section, and this provides cover for if an employee of the insured makes an employment practice wrongful act allegation against them as a company, the policy would respond to that. And then your corporate legal liability section, which is your claims against your entity. And as you can see there, there's a wide range of different covers that is included in each section. But I'll go into more detail now to each section and what that means. So if we just pop over to the next slide. So the first section I'll talk about is the cover for directors. This is the section that I always say that is the most important section. Directors have a lot of duties in their role, and they are personally liable if something goes wrong. If someone brings some sort of allegation against them for any sort of wrongful act, there's a lot of potential outcomes that would happen. And one key thing that I always say is that a claim can arise from anywhere, and they don't have to be justified or factual. There doesn't have to be any merit, but if someone brings a claim against them, they're going to have to defend that, and legal fees can be costly. Even if there's no wrongdoing, they still have to pay legal fees to defend that matter. If they don't have a policy in place, they're going to be personally liable to pay those defence costs. And in the event that something has gone wrong, and they're also have maybe fines or awards against them, they'd also be personally liable to pay those. And again, if there's no policy in place, that can have a really detrimental effect on them. Some outcomes, if claims are made against them, is that they can be disqualified as a director, and that doesn't necessarily mean just the director of that company. They can be stopped from being a director from any companies. There can be criminal prosecutions, which can lead to custodial sentences. If there's awards, fines, penalties that need to be paid, that can cause financial hardship and lead to bankruptcy. So there's a lot of possible things that can go against the director, and if they don't have cover in place, they're going to be up against some real hardship. And the policy is there to help cover these sorts of claims. We'll cover claims for wrongful acts against the directors, tax investigations, pollution investigations, and just making sure that they've got that support in their roles. If we move to the next slide, I will talk about the corporate legal liability section of the policy, and this is claims against the entity itself. So these claims are involving the business, but you can get claims as a sole target of just the business or jointly with an individual. So, for example, if the HSE decide to investigate an insured and decide that there's been issues with that entity and want to prosecute, depending on what's happened, they might also decide to prosecute the director as an individual. So there's potentially 2 claims that could be made against one of the clients, and the policy would respond to both of those. So they'd respond to the claim against the entity under the corporate legal liability, and also the claim against the director under the directors section. So sometimes you can see multiple claims under the policy for one set of circumstances. Some of the key sections under this that we do cover is contract disputes, which is quite a big one. You might have a insured who is dealing with a lot of clients, a lot of suppliers. If something goes wrong and escalates, that can be a contract dispute claim, and they can escalate quite quickly. There could be potential damages to reputations, survival of the business, depending on how much costs are involved and how much that relationship can get damaged. And the policy is there to help respond not only for claims made against the insured for a breach of contract or a dispute, but also there is some legal pursuit cover within this section if the insured needs to pursue someone for a breach of contract from their side as well. Another key point in the policy is standard cover. We include some crime, which is like employee dishonesty cover, third party fraud. So this isn't an additional section they have to buy, it's included as standard. The employee dishonesty, for example, is an IMA limit of £100,000. So if an employee has an insured that is stealing from them and that gets discovered, there's cover under the policy for up to 100k. And given the climate at the moment, this is kind of a sector that we are seeing claims growing. People are struggling with what claims are being made against them. Struggling like with financial reasons, and if there's a small business where they might have to see an opportunity that they can steal from the insured, is quite prevalent, and the policy will respond to those. Another key section is data protection breaches. So it's quite often in the news at the moment about GDPR and the focus on that. If an insured holds a lot of client data, a lot of employee data, that quite sensitive information, and there is a breach, the policy will support them into making sure they're following the right obligations that they need to who they need to notify, and rradar will support in that as well. And also under the corporate legal liability, which I mentioned before, but I think it's such a key point, is that we cover all regulators, especially the HSE and the HMRC. If there's some sort of tax investigation or HSE investigation, the policy will respond. If the HSE turn up to a client's building and decide that they want to go and investigate, they will also charge fees for intervention, which can rack up quite quickly and be quite costly, and the policy will respond to those as well. So we'll just move on to the next slide, which is the final section of the policy, which is the employment practices liability section. And this is probably the section that we'll see the most claims under. It's been a few years since the abolished tribunal fees, but we did see quite a lot of claims grow in this sector because there was no need for someone to then pay to bring a claim against their employee or former employee for an employment practice wrongful act, and that made a lot more claims come in. And now we have the new government with Labour. There is potential that they will also waive the 2-year almost like waiting period for a claim to be able to be brought. So currently you have to be employed for 2 years before you can bring some sort of unfair dismissal claim against an employee, but the new government are looking to get rid of that, and they'll have the same rights as anyone to bring a claim. And again, this could kind of see an uptick of claims in this sector. So it's important that the clients have the cover and the support in place if they do start seeing a lot more claims. Now, the Employment Practices Liability section covers claims ranging from unfair dismissal, harassment claims, discrimination claims, deduction from wages. So if an insured wants to make some redundancies and someone decides that they don't feel that process was fair, they can bring a claim against them. There's also cover for examples where if an insured is interviewing for a new role and someone isn't successful and doesn't get that role, they could actually bring an employment claim. So even though they're not actually employed, they could still allege some sort of discrimination for the reason that they're not hired, and the policy would protect them in that instance and defend in that matter. The policy will respond to defence costs to defend a claim, even if it goes all the way to a tribunal, and also respond to any awards or settlements, providing that they're not contractual. So, for example, if there's a claim for deduction of wages, if there's been a dismissal and they're alleging that maybe they've not been paid the right holiday pay or notice pay, the policy would still respond to the claim to defend that matter, but we wouldn't pay the award because that is something that an insured should have always paid as part of a contract. But it doesn't mean that we wouldn't help defend the claim even if the award part of the policy isn't covered. And again, this is why the use of rradar, which James will go into in a moment, is so important, and the excess reduction, because you can get multiple claims under this section and you'll have a £10,000 excess. But if they're using the advice line and thinking, right, I need to make some redundancies, I want to make sure I'm following the right procedure, I'll ring rradar, they'll tell me what to do, I'll follow that. Not only are you mitigating the loss if a claim comes in because you know you followed the right procedure, but you've also only got a £1,000 excess, which is a big difference for the insured. And another key point I wanted to touch on before we move on to James is that in the AXA MLP policy, there is no prospects of success clause like there is in a legal expense policy. So apart from the legal pursuit extension, the rest of the policy, there is no prospects of success clause. So an insured could dismiss someone, not take any advice, not follow the right steps, and the claim will come in. There'll be no merits to defend that matter. It could be quite costly. The policy would still pick it up, would still defend the matter, provide the support, pay the awards that were made, and then most likely get rradar to do a section on how not to do that again. But the policy would still respond. They're not relying on a prospects of success clause with a percentage plucked out of nowhere, just trying to work out whether that's going to be covered or not. So again, when you're speaking to people about what protection they have and what they need, it is quite a key point that they've got to, and that there's no success clause there in the policy. The policy will respond and be supportive for them. And I think that quite moves me nicely into James and rradar and what they can offer for the clients.
Fantastic, thanks Laura. So we just go on to the first rradar slide. So as Laura was saying, rradar's a law firm, and that's pretty important for two reasons. One, it gives clients comfort that they're coming through to experts, and two, what it allows us to do is, as a key partner under the policy, we're paid by AXA 10% of all policy premium sales to provide our services. So they're fully funded. This isn't about getting in the door and then starting to charge your clients more. This is about actually giving them the upfront advice, guidance and support before they ever get into trouble, to hope that actually through that they never get into trouble in the first place. And as a law firm, what we have is called legal privilege. So when we're speaking to a client, policyholder, client, however you want to define them, at whichever stage you are in that kind of process with them, is nobody can have access to that information, because we're a law firm, because they are speaking and taking advice about risk, legal risk, from their law firm. The AXA payment acts as a mini retainer with us, and therefore the information can't be leaked or can't be used, even if it is somehow got out of the client. So no regulator, no third party, no insurance broker, no AXA, none of you can see everything that we say to our clients, because we're protecting them. And that's a huge kind of protection that we wrap around the clients really quickly. So the Radar was born over 13 years ago to support the AXA MLP. So we're not owned by AXA, but we work with them and are embedded in that kind of policy. So our key focus is our clients, and we have a duty from our regulator, as Laura was saying, one of the 96, a minimum 96 now, to do so. So we go on to the next slide. So what do Radar do? We provide two key things, if we think of it at the end. As Laura was saying, the policy covers all investigations, all prosecutions of all regulators. So whichever your client sector is, they're covered, and that's a really easy way of selling it. But what about all of the advice and guidance? Well, actually, we cover all the sectors as well, and we cover all the areas of law that may come into contact with the client under the policy. So really quickly, because we're going to go into these in a little bit more detail, we've got the legal advisory service. That's the telephone support system, 8 to 6 Monday to Friday. We've then got the digital, the online, the digital products and the apps, again, to help people. And we've got our regulatory updates. So the legal and regulatory updates and our monthly emails to clients and our welcome emails. We do roughly in year one for a client about 14 different emails and at least 2 different webinars for them of how to utilize the service, who we are, what we do, how we can help them. But then we also have periodic legal updates as maybe laws change, or as Laura was saying, when the new government came in, we did a webinar on, look, if the manifesto is held to, these are the things that they're saying. What could that mean? Obviously, big change was, it's going to be the first thing through the door. Now, actually, the majority of changes are going to be 2026. So again, we're always updating, always doing those. The last one I saw just before coming on to this is a webinar for specific kind of contracts, which is festive contracts, and the impact on national insurance and also the pensions requirement for those people. What is their requirement? We're having a lot of questions about that. So we do have articles already, but we're going to run a webinar with one of our experts, hopefully, if we can get it organised in time for them, because then people can take a lot more information a lot quicker. So if we go on to the next slide, and again, you're going to get a copy of these, so I'm not going to read through absolutely everything. So the legal advisory service, it's 8 to 6 Monday to Friday. It's telephone, it's email, it's people. So you can get through to people and they can help on all these different areas of support. So the predominant ones at the moment are the 2 tops. So employment and human resources, because people are going to people and people want and need information and what do I do? How do I do this? And commercial disputes, because people again are people and they're going to get into dispute with each other regarding contracts that they've signed or that they wish to sign or things kind of going through there. Now, hazard a guess, really easy to do. They are the top 2 pieces or advice areas that we give. They're also the top 2 areas of claims that we're starting to see in this year, because they are the hot topics for clients. Make no amends about it. Regulatory, great, just in case it comes, and that is a huge claim when it comes. But those 2 there, they're the ones that if you're speaking to your client and you say Radar provides you support for human resources, absence management, and which we'll come on to, but also your commercial disputes, they'll let you know how you're supposed to deal with those and some of the issues you may come with. And then obviously, if the policy ever needs to be kicked in, both of those are covered as well. That probably likely they'd be happy with just that. But it's everything else. It's business, crime and regulation, which is all the regulatory bodies, the advice, the guidance, the support. What do I need to do? What don't I need to do? Do I need this tank funded? Do I need to tell my staff about certain data protection rules when they're working from home? All those kind of things. Intellectual property, which is a huge one for us in terms of a lot of SMEs that they haven't really protected their IP properly. And then they're coming into conflict with others that potentially have. Tax, and health and safety and environment. So a lot of questions at the moment about lone working are coming through. Again, we have all the teams available ready to support and kind of move clients through that journey there. If we just move on to the next slide. So I thought I'd kind of cut away from what the advice and guidance and support is first, and then we'll move back to it, just to kind of give you over our specialisms. So hopefully, as you'll notice, the covers that Laura was talking about, the areas of support that clients are looking for, all of these areas are teams within Radar. So we are a single entity where people can come into and they can get the information and support they need. We don't hive out to smaller advisory companies or, you know, those kind of things, unless they're outside of jurisdictions. The teams within Radar are the ones that are fighting the claims and have done for decades, because our teams are really, really experienced, and they're the ones that are giving the advice, because it's better to take it from the person that knows. As Laura was saying, that learning at the end of a claim is great of how not to do it again, but we're trying to bring that learning to the front before a claim even comes. So that's the kind of level of people that you're going to get access to. So next slide, please. So this slide's one that I always use, and our director of advisory services, Nicolica, who's pitched on this, absolutely hates it because she doesn't like the picture, but I've told her I'm going to keep on using it because it reminds everybody that sometimes we do things we don't really want to do, but we need to. Now, that's because it's part of your employment contract. What if you had a question? What if you were trying to do that in your own workplace? What if your clients were trying to do that? Who would you call? What would you do? Well, if you call the Radar advice line, you'll get through to either employment lawyers or HR experts. And by experts, I mean 20, 30 years worth of experience minimum in some of those teams of people working in that sector. But some of the top issues we're facing at the moment: queries on contracts of employment, salary disputes, and then also the kickback from statutory sick pay, and also still some of the COVID questions that are coming up in terms of people looking at how over a period of time they've been paid, and whether they can use when they were put on furlough as a way of saying, well, you've average underpaid me. That seems to be a really strange one. Annual leave and unpaid leave. So look, I've got my holidays, but big question from last year, and probably one for next year as well, because they've announced potentially another bank holiday, but they've wavered on it, the government, is bank holidays. How does that work? Well, that all depends on your contract, and that all depends on what you've done before. So again, ringing up and talking about that, getting that advice and being able to put it into play. Recruitment and redeployment questions and queries. How do we recruit? We're struggling to recruit. 2P, redundancy, and obviously the big ones: grievance, disciplinary, performance management, and absence management. They're the ones that are probably, I could tell you that 9 times out of 10, that's what the phone calls are about, is those 4. And it's about helping people through there. So next slide, please. So again, that's the HR, the advice, the guidance there. But as I was saying, commercial disputes are rocketing. The amount of claims for commercial disputes is rocketing. The advice and guidance is going through the roof. So what I wanted to do was try and break down some of the key areas of advice and notes that we're getting, again, so that you're able to see kind of the breadth and depth of the supported upfront, no additional cost support that we were able to give clients under policy. So commercial disputes, contract disputes, debt recovery, complaints against directors, officers, or employees of the organisation from externals regarding these kind of things. Tax, IP, passing off is huge. The amount of counterfeit and attempted passing off of companies now is steadily rising. Data protection, well, that's just a huge bag in itself, isn't it, of defending there. But again, that data protection all comes from the Information Commissioner's Office, all those regulations. So yeah, that's a regulator, so that's covered as well. So again, just try to drum it in. All investigations, all prosecutions, all regulators, and Radar support all of those in terms of advice guidance. So next slide, please. So that's what we're doing on the telephones and emails. Well, what else have we got? We've got the digital products. So the first one is Radar Station, and it's the online hub where once you've sold the policy and you've registered your policy holder with us, then they can access there and they can read the articles, and they're quick 5-6 minute articles. They're bullet points. They're what to do, what you need to do, what you don't do, what you need not to do. But also, here's the templates. So we've got contracts of employment, different variants of all of those, employee handbooks, invite letters, outcome letters, letters to staff reminding them about their duties for CPD, templates for loan working, for risk assessments and all those kind of things, and how to fill those in with your own specific issues. A great letter that we just keeps on going in terms of how we're now working as a society. A letter that dictates what and reminds staff their duties from data protection when they are working from home, when they're working off-site, you know, what they need to do, the basic minimums that you'd expect from them. And again, that isn't to say, well, we've issued that, and if there's a claim, we'll just defend ourselves with that because it was that employee's fault. It's to remind people how serious this is, and also just to maybe try and break a few habits over some time, and therefore the breach may never happen and we don't have to go down that route of defence. Radar Grace is one of our smart apps where you can download it and you can ask it questions, mainly HR and health and safety and compliance at the moment. But again, it's widely used by people whether they just want to shout at their phone and get the answer read back to them, or they just want something quick and easy that they can type into. Again, different ways of accessing the information. Also has links then back to the full articles, or click here to call the advisory team if you need to. Radar Report, which is an incident, accident and near miss reporting tool. Again, it's available for all policyholders. They can also give that one to all of their staff. So it's an app onto your phone. It is a web browse application as well. And it's your accident book, your incident book, your near miss book, all digitalized. And the key users can see all the analytics behind absolutely everything that's been reported. Each individuals can see the reports they have made. They can upload photos and short videos through it, again, because it's using their phone. What it also does is, if certain questions are answered, or if someone says, I believe this is a rradar, and it tells you what that could mean, it will alert us and the key user in the organisation to say, you two need to talk to each other. So organisation and radar, there's a potential radar here. Again, getting ahead of the game, making sure we're being proactive and responding to the regulatory requirement of reporting in the right way. We've then got Radar Risk, which is a new little audit tool. It's about 35 to 50 questions, yes, no, not applicables. And once you answer all of those, it starts to give you risk areas that, like, your regulatory risk may be really high because you've said, I don't have these things in place. Your employment risk may be high because, again, you're not doing certain processes. All of that is to get people to understand their risk and then take advice from us. And again, because of that legal privilege, when they're filling that in, it's coming to us, it's coming to them, it's privileged, so no one can look at their answers. It also then has links underneath back to the station, back to the templates to say, hey, you've said you don't have a whistleblowing policy. That's a risk from regulatory and employment. So you're higher up there. How about, here's the link, click the link, read the article. It's 5 minutes. Click this link, download the template, put your organisation name in and issue it. You then have it and you see your scores drop. because people like to see how they're doing and comparing to others. So if we go to the next slide. So that's all of that was about the proactive natures. That's all of the upfront things that policyholders get. Now is the what happens if something goes wrong. So the event of a serious accident in the workplace, and potentially a death or a serious accident, not someone falling over and breaking a finger. Really, it's someone falling and potentially dying. Serious road accidents, especially if they're hitting railway bridges. Unexpected visits from the police, the HSE, the EA, the local authorities, the fire service, any regulator or investigating body. They can call this number, and this number is 24 hours a day. This goes straight through to a criminal regulatory lawyer. They ask for the policy number, client gives the policy number, and then that's it. We're in and we're supporting, because the likelihood is that these are claims because of the serious nature of them. The policy allows us to get on and do. We've got a delegated authority up to £50,000 per case, which is hopefully moving up shortly, and we can just get on and start defending the client, because if that phone call comes in 10 minutes after the incident, we're then on the phone with them and we can start to guide what is happening. The script for the court case is usually written in the first 48 hours. And if it's 3 o'clock on a Sunday morning and you've got to wait until Monday afternoon, yet the police don't wait because they're interviewing you, then you may have already let the cat out of the bag, quite frankly, and you may be giving information in a way that it's not helpful for you later on in court to have done so. So again, it's a big area of support. It's a big point of for clients, because lots and lots of firms in the UK and worldwide pay hundreds of thousands of pounds just to have lawyers on call 24 hours a day in the event of something happening like this. The policyholder, the client, gets that as part of it. So next slide, please. So really quickly, we're probably not going to get through all these case studies because I talk a lot, as you can all tell. An employee raises a grievance. The client, the grievance was about workload and their manager leaving and all that manager's work being pushed onto them. But we then find out later on that there's actually other issues. The legal advisory service was called by one of the directors. We support them through how to hold the grievance, how to hold the appeal, the letters, the process, all of those things. Claim was made under the EPL section because the Employment Tribunal and AXA conciliation came in, and unfortunately they started to reveal other bullying and harassment issues which the director wasn't aware of and they hadn't raised in the grievance or appeal. So the claim was going to be worth at least £250,000 in terms of all the legal costs and the claim itself and awards. So they'd taken advice, so they had £1,000 excess at that point, and we were able to then settle the claim for around about £25,000 in total. So that included all of our costs up to that point. The client paid £1,000, but they also then had that next steps report of how to improve and make sure these things don't happen again. The next slide, please. And again, we can talk through all of these at a later date. Next slide, please. There we go. Yep. So this one, fatality in the workplace. A employee on a night shift, 3 o'clock Sunday morning, had climbed up a load of racking in an area of the warehousing where he shouldn't have been. Now, we can only deliberate that he probably has done this to be able to just slink off work and hide or go to sleep. Unfortunately, he fell. As he was doing so, he was about 12 feet in the air. He was about 6 foot. He fell onto a concrete base floor and died. Now, they didn't find him initially because no one's in that area. So when they did look for him, they found him. He was already dead. The supervisor rang the director. The director got dressed, and on her way in, her broker had sold her the AXA MLP, made sure that they put the crisis number in her phone with her policy number. She was on the phone to one of our regulatory solicitors who was woken by the call, went to his office and started supporting. Now, we did that crisis management. We spoke to the police when the director attended site, and was able to say, right, we'll give a statement, but in 2 days' time, when you're next on duty, officer. We did all of those things. We represented during the and protected the client during the investigation phase. We recommended some improvements for their health and safety across the site, not related to the issue, but the HSE absolutely loved that and loved to see that the client was taking things so seriously, always improving, I think was the HSE's mantra at that point, one of their campaigns. So, we're able to show that. The police and the HSE both dropped the prosecution because the CPS couldn't find enough information and evidence on a balance of probabilities to take our client to court. So there's been a death in the workplace, but because we were able to show all the training records, everything that should have been done had been done, that we could have not anticipated someone doing what they did, that both said, oh, okay, they're on a frolic of their own. They had decided to do this, and nothing that the company had done or could do could stop it. Which also meant that the family dropped the civil suit, because their no win no fee solicitor on the civil side dropped them because they had these reports. So the organisation was protected. We didn't have a prosecution, which is extremely expensive, but we were also able to support them through what is a horrible and horrific time for the directors and the officers and everyone involved in that company. Having someone that they can speak to about their worries, about what's going on, about what they're thinking about. Actually, most clients find that as, if not more help than the actual support from a legal point that we're able to give. Oh, next slide, please. Phew. That's me over.
Excellent. Well, thank you very much, James. I think we are probably running, bizarrely enough, pretty much to time. So we've actually now got a chance for a little bit of Q&A. For those of you who have been listening intently, you may well have some questions that you want to ask any of the experts. So if I could just ask again, if you need to, then you log into Slido to do so. The details are again on screen now. It takes about 10 seconds, so feel free. I am going to pick some of the questions out of that now, and I'm going to throw them to some of our experts. So I tell you, first and foremost, we'll go to Laura. So there's a question here from the Ardonna team in Haverhill. Afternoon, everybody. That asks, when the client asks what limit of cover they should have, what should we be advising other than the highest level you can afford?
It's a good question, and I would always think about the size of the business. So if you've got a really small business, the likelihood is they're probably not going to need a £5 million limit. But equally, if you've got a business that's turnover 10 million, 20 million plus, a 250k limit is probably not going to satisfy the needs. But I also would take into account the sector that they're in. For example, if they're in construction, there's probably going to be quite a few claims, contract dispute claims, HSE investigations, and it's just making sure that they're comfortable with that limit of availability. No policy is an any one claim limit, except for some specific covers that might have inner limits in the wording. So if they did have £1 million limit of indemnity and they had £1 million claim under the entity section for, say, a wrongful act, if they then got another claim in for the same thing, they would still again have that £1 million limit. So they're not exhausting the limit just within one claim. It is any one claim policy, so that's always something to bear in mind as well. But again, there are some sections with an inner limit, so it's just kind of taking into account the size of the business, the sector that they're in, and where the claims are most likely going to come for, but probably just be proportionate. But I would stress that if you do have a company with a high turnover and they're just wanting a 250k limit because they're trying to keep the cost down, is that really going to benefit them in the long run? I would be kind of pushing them for a higher limit, and the policy does write a standard up to £5 million limit of indemnity. in some cases we can go up to £10 million, depending on the risk. So it's just, yeah, assessing what your customer needs.
Brilliant. Thank you very much, Laura. I'm just looking on the Q&A. There's actually one here which I think it definitely was covered when you were talking, James, but I just want to kind of reiterate the point as much as anything else.
Yep.
We were talking, there's a question around whether or not there is a limit on the number of times that somebody can actually call Radar in order to obtain that guidance and that support.
No, so unlimited time and emails to the teams, unlimited amount of people in the organisation who can as well. So it's not just that you've got one director or one owner or one partner or one trustee. It's that the organisation give it to all directors, all managers. It really is as open as that. The more the merrier.
Fantastic. Thank you very much, James. We've got lots of questions flowing in now, actually. We've got one here. Does making a call to Radar constitute reporting a circumstance as required by the policy?
Wow, really specific there. So if you've made a call in and you've talked to one of the team, they will, a circumstance is absolutely specific. That will then be sent over to the team that deals with the circumstance notifications, and as a scheme you'll then get a separate report, not just claims reports from us. You'll get a circumstance notifications report, which we've just built the system to do. So yes, by telling us about the circumstance and discussing it with us, that will trigger the circumstance reporting. But don't expect a client just to ring up and say, oh, I've had this accident, and then suddenly that's a circumstance. We will need a bit of information, but they don't need to go to AXA direct. It comes through us.
Brilliant. Thank you very much, James. Let's have a quick look here. We've got, I tell you what, there's one here that I can probably answer from Alan Spivey. Hello, Alan. Asking about certain policies include a kidnap and ransom extension. This is available under the AXA product. It's not, and the primary reason for this is because XL, obviously partner company of ours, they write quite a lot of that business. So we sort of try not to overlap with them in that particular fashion. If you need kind of access to those kind of products, I've got several contacts over there, people who I know work in that specific arena. So by all means, drop me a line separately and I'll be very happy to put you in touch. More and more questions coming through now. How does the radar support following a road traffic fatality dovetail with the cover and interests of the motor insurer, who also provide representation? Blimey.
Right.
That's one for you again, James.
Yeah, can we do Laura questions? Anyway,
do you know what? While you're giving this answer, I'll find a very Laura-focused question.
No, I've got it already. We know how we've dealt with hundreds of these, unfortunately. So remember, what we're there to do is to protect the director and the people and the organisation. The motor insurer is there to look at the vehicle and any claims against that element. We dovetail in with any other legal support that is supporting the client, because we've got to make sure that they're not making admissions, they're not, and we're not, that could detriment either, because at the end of the day, our client is the key. What we've probably found is that as we've got that foot that straight into us telephone crisis support, is that we usually lead. Other insurers or even AXA in other areas are usually happy for us to take the lead and do all the hard work and defence work and all of that, because we're the experts into those. But we dovetail in however it needs to be at that point. But like I say, as we're a first response policy, we don't wait, so we're usually the first ones in, and our key focus is defending our client at all times. So most of the insurers are more than happy that we're defending. We don't give up. We're kind of well known for it. Hopefully that answers it.
I think so. And there's another one here, which is, I think I'm maybe displaying my own lack of knowledge here, but there's a question here regarding as well pollution cleanup, and the question from David Fitzgerald is around whether or not that is specifically the legal support, or is it also the covering up the cleanup costs? Now, my suspicion is that the cleanup costs would be more typically covered under a public liability section, but I could be wrong.
So yeah, the policy is a bit unique in this way, in that not only do we cover pollution claims, so if there's a claim from like the Environmental Agency with allegations that they've caused pollution, the policy would respond in defending that. But there is also some cover for the pollution cleanup costs. So any costs incurred by the client to clean up the pollution, or if there's been costs imposed by the Environmental Agency to get those to get that cleaned up, there is cover for those costs. It is an inner limit, so it's not exhaustive of the limit under the company legal liability section, but it is just an additional head of cover if they need to go and get a specialist in to go and clean up something where they've had a pollution issue. The policy will respond in that respect to help cover for those cleanup costs, like specifically.
Fabulous. Thank you very much. David Fitzgerald, there's another one here where you're asking whether or not we can share a typical policy schedule. That might be tricky, but what we certainly will be doing after this, there will be emails being sent out which will provide sort of supportive collateral that will give some more specifics around the inner limits and the various different sections and so on and so forth. And obviously, if there is anything beyond that you want to know, then feel free to reach out to your local relationship manager, lead underwriter, or indeed myself. More than happy to help with that. I think, there was another one here. I'm afraid it's another one for you, James. It's probably going to be the last one because we're running out of time. AXA Radar MLP overlaps to an extent with traditional CLE insurance and their helplines and digital services. So that's company legal expenses. What are your thoughts as regards to this overlap?
Firstly, thanks because I was just about to say what's CLE. Everyone names things differently, don't they? In terms of the overlap, and again, knowing Laura, and I'll keep this one because the policies, legal expenses policies, are hard to trigger. They've got prospects of success. You get what you pay for. And the MLP covers a lot more, which allows us to cover a lot more support and guidance. So instead of just being a phone in a law firm's office that rings and no one really wants to answer because, usually they have to give advice for 30 minutes and then that's it, then they can start charging. As I say, ours is all encompassing. It's all that support. There's no limits in terms of questions, queries, and time. And we're kind of that's the what was. Ours is now the what is, and it's that on steroids, really.
Brilliant. Thank you very much. And I think we'll probably finish the Q&A there. There's only a couple of minutes left, so I'll just kind of wrap up. We did actually have a poll on Slido at the beginning of the webinar, and I just was looking through some of the results of that, and actually it did evidence that actually only that 2/3 of the people who voted in that were at the neutral level or below in terms of their comfort around talking about the MLP product to their brokers or customers. So I'm hoping that this has been valuable and worthwhile in that regard. I think there is also going to be another poll up there now in which you can give us a bit of an updated picture as to whether or not you feel that you are now more well equipped to have some of those discussions. So if you want to jump over to Slido and the polls tab, that would be brilliant. As I say, we're kind of nearly out of time. I just want to take this opportunity to thank everybody for their attention, your questions, your engagement today, and just reiterate that we're always really happy to talk about any new MLP opportunities that might present themselves. As you've heard today, what we're trying to do with the MLP product is that it's more of a service proposition. It's not just we're there with a checkbook when things go wrong. We are there, we're trying to help mitigate risk. We are looking to provide that service, that extra additional layer of protection, and that's really important, and it's very, very kind of pivotal to exactly what it is we're trying to do, and that partnership that we have with Radar that James has just been talking about. And when I say that we're always happy to talk about those opportunities, I think I'd probably talk for James as well as us here at AXA SDA, because I know he's very, very keen. He's very always very happy to come out and see people, or to give individual kind of presentations or provide industry specific content, etc. So again, as ever, reach out to us. Be massively valuable in terms of actually providing a wider proposition to your customers, making that business more sticky, providing something that other people can't provide, basically. It's still to a certain extent a somewhat specialist product, but the exposures that it protects against are becoming more and more commonplace. So these sorts of things they're going to be great. They're going to be really useful for you to be able to provide them, to put in your shop window as something that you can offer to your customers, which maybe other people cannot. As I say, thank you very much for coming today. Reach out to us if you want to discuss any of this anymore. And beyond that, all that is left for me to do is to wish you all a very good afternoon, and we will see you again soon.